Hello all, welcome to the new Simply Put series by Kalam Academy. This is Priyanka Mahapatra, faculty at Kalam. So today we'll be having a discussion on the newspaper dated 11th December 2023. So the text and the context section of the Hindu newspaper was having an important article today about the listing of cases in the Supreme Court. This we would be discussing from our exam point of view. Then coming to the explain section of the Indian Express newspaper, there are some important articles about the JNK and Article 370 that we would be discussing. Again, there was an important article about the security situation in JNK right now. Okay, that is important from your internal security paper in GS paper 3, right? And again, there was an article about the historic deal by the EU with respect to the artificial intelligence. So these articles we are going to discuss today, that is displayed on your screen. So let's now come to the first article of the day, that is on the listing of cases in the Supreme Court. So why this is in news, what has happened recently? Recently, two lawyers, Dushyant Dev and Prashant Bhushan, they have separately intimated to the Chief Justice of India that he should be looking into the matter of the irregularities in the case listings in Supreme Court. So what is the issue exactly with the case listings? So what is happening that the movement of cases from one bench to another bench is very arbitrary. It is becoming uncertain because what is happening that if a case is been listed with a particular bench and thereafter the bench will issue some notices with respect to the case, and again suddenly that case has been transferred to another bench. Again, there is a question mark that if a junior judge can follow a case listed with the senior judge who is still available, right? So the two lawyers are therefore insisting upon the Chief Justice of India. Why Chief Justice of India? Because he is the master of the roster. He will decide that which cases will go where, which bench will decide which cases. So he is basically the administrative controller over the allocation of cases in the Supreme Court. So the two lawyers have insisted the Chief Justice of India that he should be responding to the problems created, to the problem seen with respect to the case listings. So now the question arises that if the Chief Justice of India is actually the master of roster, is that role guaranteed under the Constitution of India or it is established by the various Supreme Court judgments with this regard? So through the various Supreme Court judgments, we have established that the Chief Justice of India would be the master of roster. He would be deciding which cases will go where to which benches, right? And thereby it has occupied a very unique position with this regard. It has been done only to safeguard the preservation of personal liberty of the Chief Justice of India. Again, what does the rule say? The Supreme Court rules of 2013, they are very silent in this regard. But it has been explicitly written in the Handbook on Practice and Procedure of the Court. So you need to be very clear with these details. These details can come in your prelims exam. They can be asked as an option in the prelims exam that which rules, which handbook, okay, is guaranteeing the powers of the Chief Justice being the master of the roster. So this was all about this topic's discussion. So let's now come to the second article of the day, that is about the Article 370. Today we are going to get the verdict of the Supreme Court after a 16-day long hearing. In the 16 days, Supreme Court listened and it has got various petitioners challenging the Parliament's role. The Parliament's role and its decision to make any changes with the provision of the Article 370, and thereafter how the state was reorganized into two union territories of JNK and Ladakh. So here the main question is arising about the power of Parliament to make any changes with respect to Article 370 of the Constitution and take away JNK's special status, or it could have been done only on the recommendations of the Constituent Assembly of the erstwhile state. So we'll be getting the judgment today and then we'll be discussing tomorrow. So coming to the Constituent Assembly, the framers of the Constitution, so what powers did they give in form of the special status to JNK? Let's discuss that. So this is the third article of the day, that is behind the legal challenge to the Article 370 and the promise to J&K by the framers of the constitution. So in this 16-day long hearing by the Supreme Court, it has heard various arguments premised on the three basic guarantees that was given to the J&K state under special status. That is asymmetric federalism, autonomy, and the consent of the people of J&K. So the status of Jammu Kashmir is very unique under the Article 370. It is the only state in the Union of India which negotiated the terms of its membership with the Union. So the terms were not discussed with the framers of the constitution, okay, and it was directly given as it is for the printing. On May 27 in 1949, the Constituent Assembly of India, it cleared the draft of Article 370 as per the terms in the Instrument of Accession, which was signed in 1947. So there were basically three guarantees which were codified under Article 370, that is asymmetric federalism, autonomy, and the consent of the state. So under asymmetric federalism, the parliament was not given any power to make laws for the state J&K except the three subjects, that is defense, external affairs, and communication. And the parliament could only make laws with the concurrence of the Jammu Kashmir Constituent Assembly. So this was about the asymmetric federalism which we guaranteed under Article 370 for J&K. Then how the state of Jammu Kashmir was given autonomy? Because the constitution allowed for a simpler executive action only when they have to make any changes for the state powers. But for the rest of India, it was a very elaborate procedure guaranteed under Article 367. So in this way, we gave some autonomy to the state of. So again, with respect to the protection of the consent of the people of J&K, what did we do? So Article 378 stated that we needed the recommendation of the Constituent Assembly of the J&K if any changes has to be made with respect to Article 370. So in order to amend or repeal Article 370, we needed the recommendation of the Constituent Assembly of the J&K. But while abrogation of the Article 379 2019, did we seek the recommendation of the Constituent Assembly of J&K? No. So here Parliament has taken some indirect techniques. It has done something very indirectly which it cannot do directly. So here comes the powers of the parliament into question. So how far the parliament can actually stretch its original limits set by the framers of the constitution to suit the current needs? So for abrogation of Article 370, the Parliament took a very indirect approach because directly it was not having any power to make changes to the Article 370. So what did it do so indirectly? Firstly, in 2019, it made a presidential order through which it changed the meaning of Constituent Assembly of J&K. It converted the meaning of Constituent Assembly to Legislative Assembly of J&K, which was operating in 2019. So then it assumed the power of Legislative Assembly through the imposition of the President's rule, and then it revoked the Article 370, right? So this was an indirect way that the Parliament went ahead with the abrogation of the Article 370. So here the question is arising that if we weren't having any such rule like President's rule, then had the J&K Legislative Assembly in 2019 allowed for such a move for abrogating their special status? Then again, how can we make such a big change to the Constituent Assembly just by doing a presidential order? Can they be assigned a new meaning altogether? Right? So these are the basic questions on which the Supreme Court will give its verdict today. So let's watch out for the verdict. So let's now come to the fourth article of the day, that is about the security situation in Jammu Kashmir, where more arrest and more crackdown is happening on the network supporting militants. So this is very, very important from your mains perspective, that is GS paper 3, where internal security paper is in your syllabus. So why this is in news? Because over the last 4 years after 2019, the security forces in J&K, they have expanded the scope of their anti-terror operations, due to which we can see more arrest, more crackdown happening on the network supporting militants. So they have actually gone beyond their conventional way of tackling terror, that is only by gunning down the militants. Now they have gone beyond that to the funding structures, to the overall terror infrastructure. Right? So for that reason, we are seeing a sharp decline in the violence against the security forces. And also we are seeing a significant rise in the arrest of the over the ground workers. So coming to the numbers, just 4 years before 2019, the number was above 760. The terror initiated incidents were over 760, and now it has come down to 450 only. So we can see the decline in the terror initiated cases in J&K. Let's now come to cover the terminology, that is overground worker networks. So this is very, very important from our mains point of view, because it had once come in our UPSC mains that year. Students were terrified to see this terminology in their paper because nobody was aware of this term then. But now it has become very famous. It has been widely covered in newspapers and magazines when terrorism as a subject is covered, right? So what is this OGW networks? It is basically a group of individuals or individuals simply which provide support and assistance to the terrorist activities, and without actually directly participating in the combat, right? So they do not participate in the combat, but they assist and support the activities from outside in the form of logistics, in the form of recruitment, in the form of fundraising, in form of helping in the transportation of the arms and supplies, in spreading the propaganda, in facilitating the communication between the terrorist individuals, in the intelligence gathering. So in this way, they assist the terrorist activities. So according to today's news, there has been a sharpest rise in the number of arrests of the OGWs. That is from 500 to 1100 now. So here you can see a graph where you can see fewer deaths and fewer injuries among the security forces, which is a very, very good news. Right? So what is the reason for such improvement? Because the terror monitoring group in the state, a multi-agency terror monitoring group, and the state investigation agency by the J&K administration, they're working very, very proactively and attacking the terror infrastructure as a whole, including their linkages, their funds, their funding networks, their logistics networks, instead of only gunning down the militants. And they have also used the various provisions under UAPA and PSA, Public Safety Act, to book a number of people. That is, the number of persons who have been booked has risen to 2,700 in the last 3 years. And there has been institution of special investigation units in each police district for the investigation purpose of the high piling of cases of the UAPA. Because the number of UAPA cases have risen, we have actually constituted special investigation units in each police district so that the conviction in the courts happen very smoothly and swiftly, right? So seeing the numbers booked under UAPA, it has drawn criticism from the political leadership in the valley, who have accused the security agencies of attacking the normal citizens, the common people there. Right? So this is another debate again, right? But it's a good news that we have actually cracked down on the logistics, on the terror infrastructure of the terror groups now. So here we can conclude that the scale of security operations has significantly expanded beyond the physical encounters, which we had been doing so far. Now we have taken up new measures to crack down on the terror infrastructure as a whole. That is widespread detentions under the security laws like UAPA and PSA. Then the enforcement directorate and the tax raids on the funding networks. Then we have also made many crackdowns on the OGW networks and their linkages, by which the violence has decreased and the security situation is much better now in J&K. Right? So this was all about this article, and this article pointers are very important if any question comes that how is the security situation in J&K, why it has improved, what are the reasons for it. You need to know the numbers also, during which period it has increased or decreased, right? So we can conclude that the scale of security operations in J&K has actually expanded a lot. It has actually expanded beyond the physical encounters which it was doing before. It has now included the new measures, the new way of cracking down on the entire terror infrastructure. That is, uh, widespread detentions under the various security laws like UAPA and PSA. Then the ED and the tax raids on the funding networks. Also arresting a significantly larger number of OGW networks and their linkages. So these pointers are very, very important from your mains answer writing. So this is all about this topic's discussion. So let's now come to the EU's historic deal with respect to the artificial intelligence and how it has become the very first continent to set any clear rules for the use of AI. So here it has made safeguards for the law enforcement agencies, for the consumers as well. The consumers here are empowered to launch complaints against any perceived violations. And it has made also strong restrictions on the usage of the facial recognition technology, which has been seen as a mass surveillance tool for the government to meet its own demands or needs. Then it has also placed strong restrictions on using AI to manipulate the human behavior. It has set tough penalties for the companies breaking the rules of the law. And it has said that the governments can use only real-time biometric surveillance in public areas when there are serious threats involved, such as terrorist attacks. Otherwise, we are not going to use biometric mass surveillance in public areas. So these are the safeguards which the law has brought about, and the rest of the countries would look into it. Again, there has been a categorization of the AI areas of high risk and the medium risk. So high risk usage of AI has been completely banned. For example, facial recognition on a mass scale, although with some exceptions for the law enforcement. Then again, AI application based on behavioral control has been completely banned. And with respect to self-driving cars, it has been allowed but subject to some certification. Then come to the medium risk usage of AI, where it has been allowed without any restrictions, just as generative AI chatbots, but there has to be a proper documentation. A safeguard is given that there has to be a proper documentation of how the tech will work, and the users shall be made aware of those detailed documentation that how the tech will work, right? And now the rest of the countries will obviously see to the details of the law, and then they will come up with their own laws, right? So this was all about today's discussion. Thank you so much.